50 miles is the rule in Florida. If you want to move more than 50 miles from your residence at the time that a case was filed or the time of the last court order, then you're going to either need the other parent's permission in writing with a long distance parenting plan, or you're going to need the court's permission by way of a court order. So if you are looking to move more than 50 miles, then you are required to follow the rules and the procedures outlined in the relocation statute. The parent living in another state may make the relocation case easier because it's not like you're taking the child away from the other parent. But when someone is already living apart and then they want to move again, you're going to want to look at, does this increase the distance or increase the travel cost? Does it increase the hassle or the difficulty in transporting the child back and forth? Those are some of the things that you're going to want to take into consideration. So, for example, if one person lives in Atlanta and the other person lives in Miami, and the person in Miami wants to move to Opa-locka, right? Well, flying in and out of Opa-locka versus Miami is going to make a really big difference. Or if the person in Miami wants to move to California, flights or travel to and from California from Miami versus Atlanta are vastly different things. So that's the reason for it. You don't necessarily have to have a lawyer, but you do still have to follow the same legal process. So if you're doing it without an attorney, you're going to have to follow the same rules of evidence, the same rules of procedure as any lawyer would.